Hello everybody and welcome to class 26. So today we're going to start the first of a two-part lecture about expert testimony. So today's class and then your next class are both going to be focused on expert opinion testimony and Federal Rule of Evidence 702 in particular. So today we're going to talk mainly about three different concepts involving expert testimony in Rule 702, but the major point of the lecture is to keep in mind that under 702, judges are now the gatekeepers in terms of determining what testimony to allow in as expert testimony under Rule 702. The reliability of the testimony remains a crucial question. As remember, before Rule 702, it was all about how reliable is this testimony, is it generally accepted in the relevant expert community. That still remains a crucial question, but Daubert and Rule 702 really shifted the gatekeeping function from the scientific community and to judges. Under Rule 702, gatekeeping consists of 5 steps, each of which we'll talk about over the next 2 classes. So first, the expert must base her opinion on reliable principles and methods. In other words, the theory or the approach that she takes must make sense as a general matter. Number 2, the technique must have been reliably applied. This is similar to the first step, but not the same. The question is whether the expert conducted the test or applied the theory properly in this case. The third principle is that the expert testimony must fit the facts in the case. In other words, it must be helpful to the fact finder, and this requirement is stricter than Rules 401 and 402, which deal with relevance. The fourth factor is that this particular expert must be qualified. And then finally, as always, the judge may apply Rule 403. And I think application of Rule 403 is actually particularly important in the application of Rule 702 because of the value and the weight that jurors place in expert testimony. So even if evidence survives the expert testimony rules, the court may exclude the testimony for the usual 403 reasons. To admit expert testimony, a litigant must satisfy all 5 of these criteria on your screen, and note that 4 of them appear on the flowchart in your book on page 807, which I think is a helpful tool to just refer back to if you get a question on expert testimony. The qualifications of the expert, which is the only factor number 4, which does not appear in that chart, is treated separately in Chapter 62, which we'll read for next time. And that's simply because courts often analyze qualifications that issue separately. So these criteria, as I said before, all lead to the same bottom line question. Taking into account the expert label that will accompany this evidence, is the evidence sufficiently reliable, probative, and non-prejudicial to present to a jury? So let's start with the first inquiry, which is whether the principles and methods that the expert uses are reliable in and of themselves. Before a judge can assess the qualifications of the particular expert, she needs to understand the field in which the expert witness claims to be an expert. The Daubert test governs this question, and this slide really summarizes the development of Daubert. So before Daubert, courts used this general acceptance test that was also known as the Frye standard, and a few states, keep in mind that a few states today still use the Frye test. Judges would ask whether the principles supporting an expert's testimony were, quote, generally accepted as valid by the relevant scientific community. Experts, in other words, decided what testimony was acceptable and could come in at trial. And this is similar to, for anybody who's familiar with the medical field, this is similar to the standard of care in medical malpractice cases. That really is decided by doctors themselves rather than by the courts. But in terms of expert testimony, focusing on general acceptance was problematic in several ways. Some fields are developing and changing, and just because a particular approach in that field is not yet generally accepted doesn't mean that it's junk science. So for example, Galileo would not have been accepted as an expert under the Frye test, but as we know by now, justice cannot wait for science to evolve to a consensus. And many fields are contested. Some doctors will believe X, and other doctors believe Y. It doesn't mean that all of the doctors that believe X are incorrect or that believe Y are incorrect or not, sufficiently reliable to trust to speak at trial. Also, Rule 401's relevance standard is a low standard. Science requires a much higher level of certainty for truth. Science will take way too long to decide that something is reliable. Scientists might need a much higher level of certainty than that which is required at trial for relevance. The Daubert court held that the Frye standard had been superseded by Federal Rule 702 once that rule was enacted, as the sort of rigid general acceptance requirement would be at odds with the liberal thrust of that rule and of the federal rules in general, with their general approach of relaxing the traditional barriers to opinion testimony. So under Federal Rule 702, the Daubert standard, a trial judge must determine at the outset whether the expert is proposing to testify to, one, scientific knowledge that, two, will assist the trier of fact to understand or determine a fact and issue, which entails a preliminary assessment of, three, whether the reasoning or methodology underlying the testimony is scientifically valid, and of, four, whether that reasoning or methodology properly can be applied to the facts in issue. Daubert isn't a mysterious or difficult test to apply. It simply broadened the test for reliable principles and methods to include factors other than general acceptance. General acceptance is now just one of numerous factors that judges may consider. Thus, the court shifted that gatekeeping function from specialists in a field to the judges themselves. The court in Daubert finally proposed a non-exclusive list that judges could use to determine reliability. The Supreme Court has interpreted Daubert as a flexible test with the emphasis on overall gatekeeping rather than a rigid set of requirements. So good litigants, what they'll do is they'll use the Daubert factors to argue for or against particular evidence, but they'll also keep an eye on other factors and on the bottom line question, which is simply, is this the type of evidence that is reliable enough to present to a jury as expert testimony? This slide summarizes the Daubert factors for you. So first, can the theory be tested? Has it been subjected to peer review and publication? Is there a known error rate? Are there standards controlling the technique's operation? And has the theory been generally accepted? Note that that fifth and final factor does incorporate the Frye general acceptance standard, but general acceptance is no longer a controlling factor. It's merely one factor that a court may or may not consider, because none of these factors are required, nor are they an exhaustive list of factors. Courts can consider and judges can consider any factor that the judge finds useful in determining the validity and the reliability of the proposed testimony. Now here's an example of Daubert in application. So in this case, Arthur Fusting had knee replacement surgery. His surgeon used a popular implant that was manufactured by the Zimmer company, but the implant didn't work out for Fusting. He experienced a lot of pain and swelling in his knee, and ultimately the implant broke apart and had to be replaced with one from a different company. Fusting sued Zimmer for product liability and negligence, and he claimed that the sterilization process used by the Zimmer company is what caused the implant to fail. According to his case, the process that Zimmer used, which was called gamma irradiation, caused polyethylene in the knee to oxidate, to delaminate or divide into layers, and then ultimately to fail. So naturally, to present this theory, Fusting needed an expert. So he offered an expert witness by the name of James Pugh, and you can actually find more information about Pugh on his website, www.intercitytesting.com. So Pugh is a biomedical engineer. He performs biomedical and biomechanical injury analysis, and he has a distinguished academic background from MIT. Here's the gist of the testimony of James Pugh along with its limits. So Pugh gave his opinion that Zimmer's gamma irradiation caused the polyethylene, which was the material used in the knee implant, to deteriorate and ultimately led to failure of the artificial knee. But he conducted no tests of the Zimmer implant, either in actual knees or in the laboratory, nor did he do any studies of gamma irradiation and polyethylene in general, nor did he consult or describe any such studies that were done by others. Instead, he simply testified that based on basic principles of polymer science, gamma irradiation would cause a polyethylene implant to deteriorate. So this, as you might imagine, is a pretty bare bones opinion. Pugh didn't explain to the jury why the knee might have failed or explain any of the science leading to his ultimate conclusion. So Fusting basically wanted the jury to believe Pugh because he used big fancy words and he came with a good resume, and it worked. The jury did believe him. The jury awarded Fusting $650,000. So this illustrates one of the problems with expert testimony. The jury won't know how to dispute an expert's bare opinion, and this is why courts play this gatekeeping function. So ask yourselves, what do you all think? Do you think that Pugh's testimony meets the Daubert standard of reliability? Think about some of the questions that you might want to ask Pugh at a Daubert hearing. So ultimately, the district court did allow Pugh to testify. And as I mentioned, the jury returned this large verdict for the plaintiff, but the Court of Appeals here overturned the verdict because it found that the trial court should not have admitted Pugh's testimony in the first place. So why did the Court of Appeals hold that the testimony should not have been admitted? Let's go ahead and compare Pugh's testimony to the Daubert's factors. Pugh's method is a theory that the principles of basic polymer science show that gamma irradiation will cause failure in a polyethylene artificial knee. So the first question we might ask ourselves is, can the theory that gamma irradiation damages polyethylene be tested? And the problem here is that it could have been tested, but it wasn't. Next, has it been subjected to peer review and publication? The answer to that is no. Pugh shared his conclusions with no one before the trial. Is there a known error rate? Since Pugh didn't test the theory, it's not possible to know what the error rate might be. In other words, even if gamma irradiation sometimes causes polyethylene to fail, we don't know how often that happens. And then, are there standards controlling the technique's operation? This one might not apply, or again, maybe it does. This underscores that Pugh did nothing to test his theory. He didn't attempt to apply the theory, much less develop any standards to control the technique's operation. Then finally, has the theory been generally accepted? And as far as we know, it has not. It's possible that other polymer scientists would agree with Pugh, but there was no evidence in Fusting's trial of that. There was just Pugh's personal assertion. And remember, when you're applying the Daubert factors, remember who has the burden of proof. The party offering the expert testimony has the burden to show sufficient reliability. So, if the harm of gamma irradiation really is clear to polymer scientists, then Pugh has to explain that connection more clearly to the court and the jury and should cite other experts. He should also probably conduct at least some tests to apply the theory to the disputed facts. So if we step back from the Daubert specifics and we look at Pugh's testimony from a more general lens, if law students don't know much about polyethylene gamma irradiation and the relationship between them, then jurors probably don't know much about these matters either. Without doing more to apply the basic scientific principles to the facts in this dispute, Pugh's testimony amounted to little more than a declaration that essentially I think the defendant was negligent, which really is not helpful to the jury. If the jury simply defers to Pugh's testimony because he's an expert, moreover, this type of testimony changes trial by jury to trial by an expert's declaration. So there was a case in your reading for today that talks about this issue of reliability of the principles applied by the expert, and that is James O'Connor versus Commonwealth Edison Company. So in this case, the plaintiff worked as a pipe fitter at Edison, Commonwealth Edison, which was the defendant nuclear power plant. The plaintiff claims that while at work he was exposed to excessive amounts of radiation, which led to cataracts in his eyes, so he sued his employer. The defendant employer moved for summary judgment, claiming that there was no evidence that radiation exposure caused cataracts. In response to this, the plaintiff submitted affidavits from the doctor who diagnosed him with the cataracts, claiming that he was able to identify cataracts caused by radiation just by looking at the cataracts. The problem, however, was that the medical articles that the doctor cited supported just the opposite. That is that no one person can identify cataracts caused by radiation through visual inspection alone, nor was there any other research to support the plaintiff doctor's approach. He had not conducted any studies of his own and had treated only 5 patients with this radiation-induced cataracts during his 20 years of practice. The trial court ultimately rejected the doctor's affidavits and granted summary judgment to the defendant. The Court of Appeals in this case affirmed, holding that the doctor's method had no basis in scientific fact because he had not conducted any tests to prove his method and he had no scientific studies to support it. So this doctor appeared to be the only one applying this method, and it was not generally accepted in the relevant medical community. So ultimately, this was a case where the court held that the proffered expert's opinion or conclusions were not drawn from reliable principles or based upon reliable principles. Now, the Supreme Court has ruled that Daubert applies to all types of expert testimony, not just scientific testimony, not just medical testimony, even though those are the types of testimony that first generated this standard. With that in mind, keep in mind that some factors that we've listed, some of the Daubert factors, will not apply to some types of testimony, but the courts still have to use the general Daubert framework for all types of expert testimony, and courts remain the gatekeepers no matter what type of testimony. Now, this might seem a little bit awkward in some cases, especially ones presenting testimony related to social sciences or social practices rather than natural sciences, but it can be done, and here's just one example of that. This case is Conoco versus Orange County. It's a case from the Middle District of Florida, 2003. So the case grew out of a zoning dispute that arose because members of an Orthodox Jewish sect were meeting at a rabbi's home for prayer, and the county claimed that the rabbi was basically conducting a synagogue in a residential zone. So in other words, the prayers had turned the rabbi's home into a synagogue, which violated the residential nature of the neighborhood. So the county ultimately attempted to stop these meetings. The rabbi challenged the county's action in federal court, claiming that these prayer sessions did not, in and of themselves, create a synagogue in his home. The rabbi presented expert affidavits from other rabbis about Jewish prayer practices. And it might seem hard to apply Daubert to this type of testimony. Did the rabbis have did the rabbis have to conduct experiments of some type in order to sort of fit within the Daubert standard? And the answer to that is no. Ultimately, the court held that peer review publication and general acceptance sufficed. These experts offered by Konnikov had published about prayer practices. Those publications in turn appeared in peer review journals, and there was evidence that other experts generally accepted the conclusions of these rabbis. So this is just one example of many that you can find of Daubert being applied to social sciences. I mean, another example is with the motion that you all read that I filed in a trial that I had when I was a federal public defender. That motion was applied the Daubert standard and the Daubert factors to a psychological or social science type of theory called the child sexual abuse accommodation syndrome. And we'll talk more about that soon. So now we have some information about the first hurdle of these 5 hurdles in admitting expert testimony. So now we're going to move on to the second, which is related, and that is whether or not the technique that the expert employed is reliably applied. And again, this is different than the first hurdle. This is assuming that the expert has relied on reliable principles and methods. The question becomes, is an otherwise reliable technique or principle being also reliably applied to the circumstances of the case? The reliability of a method often shades into the reliability of its application. So under similar facts, one court might characterize an expert's method narrowly and say that the method was unreliable. Another might characterize it more broadly and approvingly, but then go on to criticize the expert's application of the method as unreliable. I think it is helpful to follow the latter approach and separate the two inquiries. So again, the question is, even if the expert applied reliable principles, were those principles reliably applied to the facts of the case? Here are some of the factors that courts look at when determining whether a test has been reliably applied. First, did the expert follow the prescribed rules of the method or test? Were they applied in the proper context? Did the expert rule out other explanations for a result if that is appropriate to do? So here's just one example of this second step. So the facts here illustrate unreliable application of an otherwise reliable method. This is a case involving, a true case involving the American Cemental Association, and the case is Blue Dane Cemental Corporation versus American Cemental Association. It's an Eighth Circuit case from 1999. The defendant association maintains a register of Cemental cattle, which is a particularly valuable breed of cow. Each cow in the register is categorized as either full blood or a percentage based on these very complex categorization rules. Members disagreed in this case about how to define full blood, which are the most valuable cows. So the plaintiffs complained about the defendant's categorization of 19 cows out of 138,000 in the association's database. The plaintiffs claimed that the defendant had improperly categorized these 19 cows as full bloods when they weren't full bloods. So plaintiffs filed an antitrust and RICO claims action against the association. As part of their case, the plaintiffs offered testimony from an agricultural economist that categorization of these 19 cows caused the American market for cemental cows to drop, causing a dramatic impact on prices in the American market. So here was the essence of the economist's testimony. Before the defendant's classification of these cows, both American and Canadian prices for Simmental cows was dropping. After the defendant's actions, Canadian market dropped another 26%, but the American market dropped further. It dropped 53%. So based really just on these two figures, the economist's conclusion was that the additional 27% drop in the American market over the Canadian market was due to the defendant's actions. So that was really the essence of his testimony. So what is wrong with this testimony? I mean, agricultural economics is a respected field. It's a reliable field. There are plenty of economists who will testify and who do testify at trials involving finances and financial figures. There are many reliable economic principles and applications of those principles. But in this case, the expert's application of those principles to the facts is really downright silly. I mean, there's no way to contribute the drop in American Simmental prices to the defendant's actions, especially when the prices in a neighboring country were also declining. There was no way to attribute even a 27% drop in a market of 138,000 cows to an action that involved just 19 of those cows. So the court in this case rightly concluded that this was not proper expert testimony. The economists used some acceptable principles of agricultural economics, but the court said you can't just subtract decline rates and you can't attribute the entire decline in this case to the defendant's actions because there were other trends at play. So the dispute centered on the association's characterization of 19 cows out of over 138,000. The district court rightly concluded that the testimony was an unreliable application of otherwise reliable economic principles. The expert's method was also likely unreliable. It's not clear what method he actually used other than pure speculation, which we know is not acceptable evidence at trial. There's also a case in your book that talks about reliable or unreliable applications of different expert principles. So this is Alves versus Mazda Motor of America. In this case, the plaintiff was involved in a low-speed car crash in her Mazda. Her airbag deployed. It ultimately blinded her, and she sued Mazda, claiming that the airbag was defective and should not have deployed at such a low speed. The plaintiff offered affidavits from two engineers who both examined photos of her accident, and based on a published method, they concluded that Alves was driving less than 10 miles per hour when she had the accident. So Mazda argued that these expert opinions were not reliable. The district court held that the engineers lacked sufficient experience to offer opinions on accident reconstruction, but also the court held that although the model used for estimating speeds appeared to be a reliable model, in his publications, the model's author noted it was only valid and reliable for cars traveling at speeds of 15 to 60 miles per hour, and that the model's accuracy decreased as speed declined from 30 to 15 miles an hour. So, of course, since the experts in this case applied the model to a car that purportedly traveled or was traveling less than 10 miles per hour, they did not apply the model reliably to the facts of this case. So here's just another example of that reliable application principle at play in the real world. So we've covered now the first two of the 5 Rule 702 principles. We're going to now move on to number 3, which asks the question, does the expert testimony fit the facts? In other words, is it helpful to the fact finder? This analysis sometimes merges with the other two, but sometimes it's significant on its own. So even if the expert testimony passes the first two reliability tests, it may still fail this third fitness test. In the words of 702, a judge will admit expert evidence only if it will help the trier of fact to understand the evidence or to determine a fact in issue. If the testimony does not fit the case well, it may not help the jury. So this was a big issue in the case that we've been studying this semester, and in particular in the Daubert motion that I filed in that case, which you read for today. So what are some of the ways that I argued lack of fit in my Daubert motion to exclude the government's proffered expert witness on child sexual abuse accommodation syndrome? So one argument I made was that this CSAAS was meant as a therapeutic tool and not as a diagnostic one. So in that way, it presumed that the child sex abuse had occurred, and it was really meant to help clinicians provide therapy to the abused. It was not meant to ferret out, though, the difference between children who were lying from children who were telling the truth. In addition, I pointed out a lack of fit because the CSAAS was meant as a tool to treat girls who claimed abuse, and it was not specifically validated for boys. And of course, in my trial, they were all boys who were now men who were claiming my client had sexually abused them on these trucking trips and sexually abused them when they were children. Also, I pointed out that CSAAS applied to children who delayed disclosure, not adults. And of course, by the time of my trial, all of these boys had become adults. Some of them were in their 40s, and they still hadn't disclosed any abuse by my client until, the government came looking for them right before trial. So I argued, this might be a helpful, syndrome or tool for attorneys in prosecution for child victims, because children often struggle to express themselves and have trouble on the stand. But adults, on the other hand, especially the adults in my case who were in their 30s and all the way up to late 40s, adults are better at communicating, and thus they can explain for themselves why it was that they didn't tell anybody any sooner about the fact that my client allegedly sexually abused them as children. Finally, I argued that the testimony was just not helpful to the jurors because they were smart and experienced enough to figure out for themselves that children sometimes delay or do not disclose sexual abuse by adults, and especially you could see there might be some stigma or concern for a male child in particular, male adult in particular, to talk about being sexually abused by another male. And jurors can also understand basic concepts underlying this grooming theory that the government also wanted this expert to get into. So here's some questions that courts ask when considering whether expert testimony fits the facts. They ask, does the testimony fit the dispute? Does it add a perspective that the jurors could not provide on their own? And finally, does the testimony make sense? So one issue that arises under this heading is, does the expert testimony explain something beyond the average general knowledge of your lay jury person, or does it simply state the obvious? Here's an example. Several cases allow FBI agents to testify about lingo and practices of organized crime families. For example, that only the boss can order an execution, or to explain the meaning of the term consigliere, which is an advisor or a trusted one who may be second highest to the Don. This is testimony that is typically beyond the general knowledge of your average lay jury person. And so this is something that a court would find would be helpful to the jury to hear about from an expert, say an FBI agent who has studied for his or her job, who has studied these organized crime families. On the opposite end of that spectrum, here's an example of a case in which the court found expert testimony was not helpful to the jury. So in this case, this is Braun versus Fuji Heavy Industries, and this is from a district of Maine in 1993. So in this case, Arthur and Gloria Braun were driving through Maine in their Subaru when they collided with a deer, which was not good for them and, of course, not good for that poor deer. So having suffered serious injury, they sued Subaru for negligence, claiming that the company should have made the car more crashworthy. Now, to support their negligence claim, the Brauns offered an expert to testify that collisions between cars and animals are foreseeable to car manufacturers, and thus Subaru was negligent and should have foreseen this potential accident and was negligent in not making a car strong enough to withstand this type of impact. The judge ultimately held that the jurors of Maine could readily understand, quote, the foreseeability that cars and animals will collide with ensuing injuries. And so this judge excluded the expert testimony as simply not necessary and not helpful to the jury. So this sort of begs the question, if it's not necessary, if it's not helpful, if jurors can use their own common sense to draw the types of the conclusions that the expert's trying to draw for them, why do you think plaintiffs even offer this testimony? So not just in this Braun case, but think about my case. Why did the government, in my case, want an expert to testify about the child sex abuse accommodation syndrome? Can't the jury figure out on its own that children may not disclose sex abuse because of embarrassment or fear of reprisal in some way, or maybe mixed feelings because they have some sort of kinship relationship or positive emotional relationship with their abuser? Isn't it also obvious to the average juror that an abuser tries to lure the child and gain trust through gifts or other ways of sort of less malevolent ways of seducing the child before engaging in sexual interactions? The reason, generally speaking, why plaintiffs or prosecutors, whoever tries to use experts is because experts influence the jury. So plaintiffs could make this point or draw this conclusion on their own in this Braun case, but they wanted to give the point an extra punch or impact by putting it in an expert's mouth. So that's another reason why it's so important for judges to serve as gatekeepers in this area of the law. So this is a final case that illustrates how gatekeeping on expert evidence can affect the outcome of a dispute. So this case is Rowe Entertainment versus William Morris Agency, a Southern District of New York case from 2003. The proposed expert testimony in this case poses some interesting and sort of deeper questions about what types of testimony will help a jury. So here the plaintiffs were 4 concert promotion agencies that were staffed by Black professionals, and they sued top booking agencies and corporate concert promoters that were all run by white individuals. The plaintiffs claimed that the all-white defendants had conspired to keep business from Black promoters. The plaintiffs introduced evidence related to this particular industry, and they also proposed more sort of broad or general expert testimony of a man named Joe Fagan. So Fagan is a distinguished sociologist. He's the former president of the American Sociological Association. He is a widely published expert on racism, and there's no doubt that Fagan uses reliable and generally accepted methods in his research. His work is widely cited. It's admired by other psychologists. He's listed in a book called The Professor's 101 Most Dangerous Academics in America. In the Roe case, Fagan would have offered testimony about institutionalized racism in various business sectors. He would talk about unconscious or implicit biases throughout American society. And the plaintiffs offered this information as background for their more specific claims and evidence on the concert promotion industry. So the question for the judge was, would Fagan's testimony be helpful to the jury? And so I'm turning that question around onto all of you guys. What do you think? Do you think that this type of testimony fit the facts of this case? So many sociologists would say that Fagan's testimony was the most helpful information that any decision maker could have. Sociologists see human behavior as highly patterned. They focus on these social patterns rather than on individual decisions to explain human behavior. But the problem is that the law tends to see things differently. So discrimination law in particular focuses on individual decisions and individual behaviors rather than these larger unconscious social patterns. The district judge applying that view concluded that Fagan's testimony would not help the jury. So ultimately the court excluded the testimony and told the parties that it wouldn't be helpful to the jury. The court believed that the jury should focus on the facts of this case and this particular industry and not on these more general patterns and conclusions about American society. So, for example, sociologists like Fagan would say, this general information is helpful in this case because people act in socially predictable ways. The court's response, however, would be that the law focuses on the individual intentional acts of discrimination and not on basic trends that may unconsciously follow social patterns. By excluding Fagan's testimony, the court affirmed this focus of the relevant law. Now, some courts have admitted evidence similar to Fagan's testimony, although the matter is somewhat controversial. So the controversy illustrates that helpfulness, kind of like this idea of relevance, depends on legal standards, it depends on cultural norms, it depends on advocacy of the parties, and obviously it also depends sort of on the viewpoint or the discretion of the trial judge in your case. This case is from your reading, and this is an example provided in the textbook about this third factor, this fit factor. Porter versus Whitehall Lab is a medical malpractice lawsuit. The plaintiff fractured his toe at work, and his doctors prescribed ibuprofen, which is a pretty common pain reliever, while he waited for a surgery to reset the bone. Shortly after the surgery, the plaintiff experienced kidney failure, and even with a kidney transplant, unfortunately, he died within a few years. So Porter's estate sued the drug companies that manufactured the ibuprofen, claiming that the ibuprofen is what caused his kidney failure. To show that the drug caused kidney failure, the plaintiff offered affidavits from several experts. The trial court excluded these affidavits and actually granted summary judgment to the drug companies. The Court of Appeals, in this case, affirmed that decision, finding several defects in the expert's testimony. One was a lack of fit. Dr. Benjamin was a pharmacologist and admitted he could determine whether ibuprofen caused the plaintiff's kidney failure only if he knew whether the plaintiff was taking other drugs at the time. If he knew more about Porter's overall health, that would also be helpful. And if he was able to rule out various environmental factors that contribute to kidney failure, which he could not do. Since the parties were unable to supply this information, the court concluded that this doctor's testimony did not fit the facts of this particular case. But you can see how this case might have come out differently had the proposed experts had all of the information that they needed, right? So if they had known more about the plaintiff's overall medical history and health and whether he was taking any other medications or drugs at the time of the kidney failure, if there were any other environmental factors, if they'd had that information, a court very likely would have allowed the expert testimony in this case. So these three questions that we've talked about, reliable principles and methods, reliably applied, and helpfulness or fit, are not the only three questions that judges must ask under 702, but they are the heart of the inquiry. Other issues arise, which you saw, of course, in my Daubert motion, including whether the expert's opinion is too conclusive, for instance, usurping the function of the jury. Other questions include the bases for the expert's opinion and his or her qualifications, which we'll talk about next time. In addition, there's Rule 403, which is an important rule not to forget about in any context, but in particular in the context of expert testimony. 403 analyses are particularly important here in this context, since jurors place a lot of emphasis and weight on expert testimony. So just keep in mind that 403 forms the third step in a three-step analysis that courts undertake when evaluating expert evidence. So first is the question of reliability. Second is the question of fit and helpfulness. And then third, even if the evidence satisfies these conditions, does the danger of unfair prejudice, confusion, or misleading the jury substantially outweigh the probative value? And that's sort of a fallback position, but it's an important one that I, of course, relied heavily on in the motion that you read from my trial. So finally, just briefly, I want to touch on the Supreme Court's decision in Kumho-Tyer versus Carmichael. This decision solidified what I told you earlier in the lecture, which is that the Daubert principles do not just apply to scientific or medical testimony, but to any expert evidence involving specialized or technical info that is beyond the understanding of the average juror. Criteria that a court considers when assessing expert testimony will vary depending on the type of expert evidence at issue. And so let's briefly review what happened in this case. So in this case, the plaintiff was driving a van when a tire blew out, causing an accident that killed one of the passengers. The plaintiff sued the tire manufacturer, claiming the tire was defective. The plaintiff relied on the testimony of an engineer as an expert in tire failure analysis. The expert testified that a blowout occurs when the outer tread of a tire separates from the inner steel belted carcass of the tire. Carlson claimed that this separation could occur if the tire was underinflated by the car's owner or a manufacturing defect, but he further testified that he had inspected the remains and found no signs of underinflation, such that the defect must have been caused by the defendant, the manufacturer. The defendant disputed this testimony that a blowout occurs for only one of two reasons, that with the expert's method of determining underinflation from the tire's remains. The district court agreed with the defendant and excluded the testimony, applying the same Daubert factors that are applied with respect to scientific or medical testimony. The plaintiff appealed the decision, and the 11th Circuit reversed, holding that Daubert should be limited to the scientific context, and thus this expert's testimony falls outside of the scope of Daubert, and the trial court should have considered non-Daubert type factors. Ultimately, in this case, as you know, the Supreme Court granted cert in light of lower court uncertainty over whether and how to apply Daubert to non-scientific expert evidence. The Supreme Court held that Daubert applies to every type of expert testimony, not just scientific. Also, it was appropriate for the trial court to consider the Daubert factors to the extent that they could be applied to this engineer's testimony. Daubert set forth a flexible test, and the trial court has considerable discretion to determine how or whether to apply one or more of these factors mentioned in the case. So in this case, the trial judge applied a sufficiently flexible standard in evaluating Carlson's testimony, and that judge did not abuse his discretion in excluding the testimony. So that is the basic holding of Kumho-Tyer. And, you know, for this case, you should just be familiar with the fact that this is the case that set forth this broad principle that the Daubert test applies not just to scientific and medical expert evidence, but really to any type of technical evidence that requires expert testimony. Okay, so that's it for today's lecture. As I said earlier, next time we are going to continue our discussion of expert testimony by talking about qualifications required of experts, as well as other issues that commonly come up with respect to expert opinion testimony. So I will talk to you and see you all then.